Okay, good afternoon. This is Andrew Bluestein. I'm the Vice Chair of Garfunkel Weil, and I wanted to invite you all to this webinar. This webinar is entitled Exiting and Entering Contracts in the Age of Coronavirus. So I hope that everyone who's home is healthy and trying to keep sane. This is the first completely remote webinar we've hosted. So myself and my co-presenter, my dear partner, Roy Breitenbach, we are in separate areas, separate homes, as is our IT department, who I want to thank because we had a complete crash right before this. So if you had trouble getting on, I apologize for that. But in the age of coronavirus, as our title goes, everything that can will go wrong. So bear with us as we do this. We about, I would say a month ago, if you had asked me to list the top 10 points that you need to focus on in every contract, let's say I was teaching a class in law school, I would not have put coronavirus on that list. It would not have been something that I would have thought was crucial, not like limitation of liability. That has changed. We now are seeing how important these provisions are. And we are looking at them in two ways. And that's really the purpose. This webinar was kind of birthed out of all of your questions, which were, and still remain, how do I get out of this contract primarily? But they're starting to be, and now what do we do in the future? So we're going to try to hit both. We're going to get a little technical for those non-lawyers on the phone, but unless you kind of get into the weeds, and Roy's done some incredible research, unless you get into the weeds, you really can't understand the principles that you'll need to negotiate and change your contracts. So we have also made some assumptions that most of the people on the call are really people who receive services. Yes, some of you may provide services, but we're assuming that most of you are receivers. And the contracts questions that you're asking is, how do I hold our vendors to their contractual obligations? So let's go to the next slide. And we'll start our introduction. So to say the least, COVID-19 has made it very difficult for people to receive and also provide the services, obviously, that they need. Many of you, or most of you, are really from the healthcare industry, and we have gotten, whether it's masks or ventilators or any kind of, we had one, a cleaning service wasn't going to come. So we are feeling your pain. And what we're going to try to do is, in addition to explaining this concept of force majeure, we're going to talk about some kind of sister arguments that you could bring up, such as the impossibility of performance, impracticability of performance, and frustration of purpose. So let's go to the next slide. Now, when we have to kind of define our scope on this call. Obviously, without having your contract in front of me, we're extremely limited about our ability to advise you. So we're talking generally. We have a task force here at GW, which is reviewing tons of contracts that we have gotten sent to us, and we'll continue to do that. So this is going to be kind of global view of the situation. Governing law. Now, one client called and said that, well, listen, I'm sitting in New Jersey, and by the way, we're going to cover New Jersey, Connecticut, and New York. We obviously, time permitting, can't cover every single state. But they said, well, we're sitting in New Jersey. The contract is for services in New Jersey, so New Jersey law applies, right? I said, well, send me the contract. And when you look at the contract, again, something which we all pay attention to, but not so much, about governing law, a lot of times we split the baby and we say, well, as long as venue is where we are, we can have governing law somewhere else. As Roy is going to get into, the governing law is different. For example, New York and New Jersey are very different. Okay. The next one that I wanted to just hit before we get more into this is taking a strategic approach to vendors. And that really means two things. One, don't go after every single vendor because they're not all equal, right? But you have key ones that you should be pulling out those contracts, okay? But what we also mean about taking a strategic approach is you don't necessarily have to start having the big bad lawyers go after them. Of course, we'd love to do that for you. But for example, we had a medical organization that had taken out a gala and, you know, catering and all that other stuff. It was a very expensive contract. And we called up and we said, listen, given everything that's going on, how about you be a little kind? And literally, that was the word we used. And they got back to us within 24 hours. They said, we're going to consider the contract void. And if you'd like to reschedule now, and actually they rescheduled for a year from now, God knows this has to be over by then. So that's what we mean about strategic. It's not always necessary to start screaming. And what they told us at this particular venue is that the people who were screaming at them, they were actually ignoring. So that's the second point. Again, we're going to be assuming that you are really a receiver of goods or services, but obviously, like we were helping a hospital where their obligation was to staff a clinic of another organization, and they just couldn't, they don't have the resources right now. We get that completely, and there we'll do what good attorneys do and be schizophrenic and look at it from the other perspective. The next one is preparing the record. This is important. We think that we're getting calls from people saying, hey, you know, we don't have this event for 7 months. Okay. So we don't want to make a decision now. Well, the problem with that approach is as you get closer in time, because if I were a judge, I might say, well, why didn't you send the venue? Let's stay with the venue example. Why didn't you send them a letter or reach out to them earlier? You were trying to see what happened, and now you made it more difficult for them. So what we mean by preparing the record is get those emails, those letters, whatever it is, out to show, and Roy will hit this too, that part of it courts will look at is, did you give the other side an opportunity to mitigate their damages? So the longer you wait, the worse it's going to be. And also we anticipate that while we're getting flooded, depending on when this crisis ends, we may end up in a situation where there's a huge rush at the end, and you want to try to see if you can get out of contracts now before it's too late. And the last point is really, how will COVID-19 change the law? Roy and I, when we were preparing for this, and as you can imagine, we did it rather quickly, so only send us praise, keep the negative comments out. But this is going to change. When Roy talks about Connecticut, there isn't a lot, for example, even in force majeure litigation in the entire state. But this is going to lead to changes. So all we can do today is kind of tell you what the lay of the land is, and then be in a position to kind of go with the changes as they develop. Okay, so let's go to the next slide, and I'll be done with this slide, and then Roy will take over, and I'll pick it up towards the end. So we wanted to talk about also that maybe, you know, I'm kind of prejudice, because that's what we're getting right now, towards all the supply and service agreements that are coming in. But we've been looking at it for employment agreements with all the layoffs and things like that. Real estate leases, we have a million questions. Can I stop paying my rent? By the way, on that one, and we're probably going to have a separate webinar on real estate leases in general, but it's the same point. I had a provider speak to their landlord, and the landlord gave them what I'm calling a rent holiday. People are all feeling the pain, and as the landlord's lawyer said to us, is the landlord is freaking out because he doesn't want 90% of his properties to be in default. So now is a good time to be strategic. Mergers and acquisitions agreements, I'm going to make some comments about that, but there's a lot of things in the works. Do you have to go ahead with those mergers and acquisitions? Should you? We'll talk about that. And shareholder agreements even. So really every contract will be affected in some ways by COVID-19. So I'm going to turn it over to Roy, and just a word on Roy. Roy is a very, very experienced litigator. He does a lot of commercial disputes, a lot of employment work, and has really been a leader at our firm for many, many years. So Roy, take it away.
Okay, thank you, Andrew. I'm going to move now to the next slide, which will get into some of the more substantive things. And, you know, generally, everybody is using the term force majeure, right? We're throwing it around. If you did a search on Google in the last week or two, there's tons of stuff on force majeure. But what does it really mean? What does a force majeure clause really mean? So at Andrew's suggestion, we went back to law school basics and we looked at Black's Law Dictionary. We dusted it off our shelves. It probably hasn't been opened up since we graduated from law school. And we looked at the definition of force majeure. And it says that a force majeure clause is a contractual provision allocating the risk of loss if performance becomes impossible or impracticable. And you're going to hear me talk a lot about impossible and impracticable and what the differences are of both of them, what they mean and where they apply, especially as a result of an event or effect that the parties could not have anticipated or controlled. And that's another huge concept in this entire thing. It has to be an event or effect that the parties couldn't have anticipated or controlled. Third-party event, act of God, act of some third party that was unforeseen at the time that they engaged in the contract. All right, so now most contracts have force majeure clauses of some types, so we're going to focus on that first, and then we're going to go into what happens if you don't have a force majeure clause, or what happens if you have a force majeure clause, but your particular event is not listed in that force majeure clause. So let's now go to the next slide, which is an introduction. Okay, so as we said, okay, force majeure event is an event beyond the control of the parties that prevents performance under a contract and may excuse non-performance. Cited a New York case here. There are tons of New Jersey cases as well. And they excuse non-performance where the reasonable expectations have been frustrated due to circumstances beyond the party's control. And that's a key point to this entire thing. In the Kel-Kim case that you see cited here, it's a New York Court of Appeals case from the late 80s. The principle there was that a party was seeking to get out of a contract because it said, look, there's a union dispute, it's closed, no one wants to walk the picket lines, so I got to have an excuse on my lease. I got to get out of my lease. And what the court said is that, well, the strike was not beyond your control, okay? The concept was that the strike, you produced the strike. You decided that you didn't want to pay your workers that extra % raise. So it wasn't an unforeseen event. It wasn't an event beyond your control. It was an event that you could have controlled, okay? So the concept of unforeseeability and lack of control will run through this entirely. And, depending on the appropriate level of the nature of what your clause says, it seems to us that in most cases on the question of unforeseeability and beyond your control, COVID-19, at least as of now, was certainly beyond control and certainly unforeseen. Now, there may be some contracts in which there's evidence of parties talking about it beforehand and talking about what would happen if there was a pandemic, and we'll talk about that later. But it would seem to meet the definition in many cases of unforeseeability and lack of control. So you're going to hear this a lot as we talk. There's some differences in the states about how you interpret force majeure clauses. New York law has a very restrictive, conservative view of force majeure clauses, okay? The courts have always said in New York that they're to be narrowly construed. You got to look at them and interpret them narrowly. They are not necessarily favored, and they're going to have a very, very restrictive view. The concept is that parties should honor their contractual obligations. And if you don't honor your contractual obligations and you're using some third-party event as a dispute, as an excuse, we're going to look at the situation very carefully and see if you're not trying to take advantage of the situation. And the other concept is no matter what we're talking about here, it's the contractual language that dictates the application, effect, and scope of force majeure. So you always have to go to the language, the actual language of the individual force majeure clause in your contract. A great example of this is something that Andrew just alluded to at the beginning regarding real estate leases, okay? The standard real estate lease and most other commercial real estate leases that are non-standard forms, you have a force majeure clause in them, okay? You may look at the list of events that trigger the force majeure clause, and you're going to see that there's probably stuff that comes pretty close to a pandemic, all right? So you seem like you're in good shape. But then when you read the force majeure clause, the standard clause in commercial real estate leases typically says that, yes, you can excuse performance if one of these events happen, except for the fact that the tenant is not excused from paying rent. So that's what controls. You have a contractual provision, you have a force majeure clause, but that particular force majeure clause says, sure, you may be able to get out of other obligations, but even if this terrible event happens, and it still has to pay rent. So it's very important for you to look at the actual scope of your force majeure clause. Now, as kind of an outgrowth of New York and its conservative view of force majeure clauses, in New York, a force majeure clause is triggered only if the event is one that is specifically included in the events list in the clause. So usually your force majeure clauses have a list of events that trigger them. Strikes, acts of God, war, insurrection, riots, whatever. It goes down a whole earthquakes, tornadoes, terrorism, goes down a whole long list. New York says if your event is not listed in that provision, okay, you don't get the benefit of it. The force majeure clause doesn't apply. It's one of the more restrictive states in the country on that concept. Now, many clauses have expansive language at the end of that clause. Some type of the lawyer language, including but not limited to. So we'll have a long list of events, or it'll start out those long listed events. It'll say events including but not limited to. Okay, so the questions that the courts in New York have confronted for many years, and this team marketing case is a case in point, as to what does that mean, including but not limited to, or similar types of expansive language. And what the New York courts have said is, all that does is it allow you, if your event is not listed, the determination then becomes whether or not your event is similar in a similar category to those events that are listed. So, for example, if pandemic's not listed, but there's something about illness, unforeseen medical conditions, the argument is pandemic is included in that if you have an included but not limiting to clause. So the question that the court will have to deal with in the first case in those types of situations is my triggering event, does it slide into one of the other categories? And again, New York is going to be pretty restrictive on that, unlike many states. So let's now turn to New Jersey. New Jersey has a much broader, more liberal approach to force majeure clauses, okay? Which is why if you think that you want the benefit of a broader force majeure clause because you're a provider of services and you have the choice of law between New Jersey and New York, maybe you should choose New Jersey law in appropriate circumstances because there's a much more liberal construction, okay? You look at them like any contract by looking at the surrounding circumstances and the purposes of the contract. This is kind of lawyer speak, so bringing in kind of equitable concepts and things like that so courts can look at the actual facts. So maybe your clause doesn't exactly match the COVID-19 pandemic, but given everything that's going on, it may give the ability of a judge to kind of stretch things a little bit, right? And then there is the key case which talks about the fact that a clause is going to be given a reasonable construction in light of the circumstances. So that's kind of like a code word for lawyers to indicate that you're going to have a lot of equitable considerations, and therefore they're going to be a little bit more workable when you have a situation like COVID-19. Connecticut law is somewhat similar to New Jersey. As Andrew said before, though, there's not a lot of case law in Connecticut on force majeure. Now, as things develop now, given what's going on, we think that in the next 5 years there will be, more law on this topic. But right now, Connecticut is saying courts will enforce force majeure clauses as written, which means, again, it goes back to you got to always look at what the clause says. And what the clause says is what will be applied. And one interesting issue about Connecticut, and it's a Connecticut case, one of the few clear directions in Connecticut, but it would also apply in New York as well, in New Jersey, is that a strongly drafted force majeure clause can even override an argument that the unforeseen event rendered performance impossible. And I'll talk a little bit about the facts of this Stanley Works case because it's instructive on this concept. So Stanley Works case was essentially a case involving a business and the ability of Halstead, which was a manufacturer of workbenches, and had a supply contract with Stanley Works. So the dispute arose when Stanley Works rejected the drawings that Halstead had given them for the design of the workbench. The way the contract works, Stanley Works gave Halstead a license for Halstead to use the Stanley name on its workbenches, and Stanley agreed to sell those workbenches in its store if it approved the design. Well, lo and behold, Stanley refused to approve the designs, and so Stanley never sold the workbench in its stores. The agreement had a provision that Halstead would pay a royalty, a licensing fee, to Stanley for a number of years to have the right to use the Stanley name on its workbenches. And when Stanley Works sued Halstead and said, okay, you got to pay me the license fees, Halstead said, well, force majeure. You guys didn't approve my design. The workbenches never got sold. Wasn't my fault. Therefore, I don't have to pay this licensing fee. And when the court looked at the force majeure clause, the force majeure clause clearly said that the licensing fee was payable even if no benches were sold and even if Stanley never agreed or accepted the benches for sale. So therefore, even though from the standpoint of the manufacturer, there was an unforeseen event that rendered performance impossible because Stanley had never acquired the benches for sale, they still had to pay the licensing fee because That's what the clause said. So it's a very important point. And Andrew will pick up on this later on when we talk about issues concerning how to protect yourself if you're a service recipient going forward. You could also use force majeure clauses to compel the delivery of services or goods at the time of a crisis. So let's now go to whether or not COVID-19 would be considered a force majeure event. Again, this is very much clause specific. But if your clause says that a force majeure event is a pandemic, the World Health Organization talked about it as a pandemic. Also, it's clearly based upon the various declarations that it's an epidemic, and federal, state, and local governments have declared states of emergency. So if you have a clause that talks about providing services in times of emergency, you're pretty good there. Government shutdown, isolation, quarantine. If you have referencing those types of phrases in your clause, it should cover under that. And finally, there's the term that's in most, which is an act of God, which is usually interpreted as some event that's unforeseen, beyond the control of either party. There's arguments to be made, obviously, that COVID-19 is such a force majeure event. Let's now go on to a key point, which is the relationship between the event and non-performance. And the key point here to remember is the occurrence of the event is not an automatic free pass on obligations. And I'm sorry, something happened and it jumped one. I apologize. So I'll go back. Okay, occurrence of the event is not an automatic free pass. Just because COVID-19's happened, you don't get to not honor your contracts in general. There has to be a direct connection between the force majeure event and why you are not performing. The key case on this is a Hawaii case from 2003. That case was a business tried to use 9/11, saying it was a terrorist incident, and therefore fell under the force majeure clause to get out of a contract to have a conference in January of 2002. And the court said no. The reason why you didn't want to have the conference is that people didn't want to come to your conference. It had nothing to do with terrorism. It was 3 months afterwards. It wasn't related. You failed to show how the actual event of September 11th rendered the conference impossible to perform, or you couldn't perform the conference or couldn't provide the services. So that's the concept. You have to tie back your reason of non-performance to COVID-19. I can't perform, or performance is impracticable, if that's the standard, because of COVID-19. You must have a direct relationship. Again, it's not an automatic free pass. And as we've talked previously, the event absolutely has to be unforeseeable at the time of the force majeure event. It can't be something that you guys talked about and tried to allocate, you tried to allocate during the course of your contract. Okay? We've already talked about this. A party can't take advantage of a force majeure clause when it has initiated the action that led to the lack of performance, right? And as always, as Andrew talked about at the beginning, you have to mitigate against damage caused by the event. So what that typically means is as soon as you realize that you may not be able to perform because of a triggering event, you need to let your counterparty know. Because there may be steps that they can take to mitigate that they should that will be lost if you wait down the line. It is almost absolutely certain that if you get into a dispute about the use of a force majeure clause, that the key item in discovery is going to be, when did you guys learn about the force majeure event? When did you decide you couldn't perform? And how long did it take you to inform your counterparty? Those are all key issues you have to be very careful about. Okay, let's talk about the burden of proof, which is a key point in force majeure clauses and varies from state to state. In New York, unless the clause provides otherwise, force majeure events must truly make performance impossible. That's an old English common law requirement. performance has to be impossible. So what does that mean? It means destruction of the subject matter of the contract or destruction of the inability to perform. Classic thing, you're going to rent the building and the building gets destroyed by fire. Landlord can't perform. The subject of the contract has been totally destroyed. That's impossibility. You're unable to perform because of impossibility. For example, if your force majeure clause has a government regulation as a triggering event, and now your nail salon is closed because of the governor's order, you're unable to perform or provide nail services to your customers. It is a force majeure event. You're unable to perform, completely impossible, unable to perform by something that's beyond your control. Now, what this means and what's important for many businesses, if impossibility is the standard that applies, financial hardship, lack of profitability, or just general impracticability, you could perform, but it will be really difficult, is generally not enough in New York to get you out of performing, unless the clause says otherwise. And that's an important point. If your clause is silent on the standard is impossibility of performance. Now, New Jersey has a much lesser standard. In New Jersey, the standard is impracticability, not impossibility. Okay? So the event has to be beyond the party's control and serious enough to interfere materially with the performance. So it doesn't have to render your performance impossible, but has to be beyond your control and just be serious enough to interfere materially with your performance. Make it real difficult. Not a little difficult, not inconvenient, not unprofitable, but really significantly difficult. All right? And then, has to, for example, be a significant financial hit, has to make a significant delay in your ability to perform. Something that's real significant. But it doesn't have to be impossible in New York. Again, I can't emphasize this enough. The language of the clause controls everything. It can override all standards. It typically provides when a triggering event occurs and often contains strict notice provisions. The case I cited in the middle of this slide, the Chase Manhattan Bank case, that's another example where a clause can provide that the force majeure event does not excuse performance. You can even say, if there's another pandemic, you have to still provide, and that's fully enforceable. All right? So let's now go, what happens if my contract doesn't have a force majeure clause, or what happens if it does and my event's not listed? In that case, then, you may have to rely upon one of the common law doctrines, such as impossibility of performance or impracticability of performance. Another point that I think is important to understand is that many force majeure clauses contain a catch-all provision that say something like, after the list of triggering events or any other unforeseen circumstance beyond the party's control that renders performance impossible or impracticable or something like that. So that's something that you should look at. The other point that I want to make is if that your particular triggering event is not listed within the list of triggering events in force majeure clauses, and you're not going to go argue that an impossibility of performance or something else under the law, the first thing that the court is going to ask themselves is, hey, is the reason why this particular triggering event not listed in the force majeure clause because the parties just didn't think about it, or because they did think about it, discuss it, and decide that that event should not be used as an excuse for not performing? So it's important to consider that. For example, is the reason why pandemic is not listed in your clause because the parties at the time didn't think that would ever happen? Or because the parties did think it could happen, talked about it, and decided that that should not be an excuse for performing? And so courts would look back as to what the parties talked about, what the documents are at the time, to kind of flesh that out and get an understanding of that point. So that's something that you have to consider. But the impossibility of performance, which is what New York would follow if there's not an applicable force majeure clause, talks about the fact that an unexpected intervening event must have occurred. The parties' agreement must have assumed that such event would not occur. So that's be completely unforeseen. And the unexpected event must make the contractual performance impossible. Same standard we talked about before, complete destruction of the subject matter or the ability to perform under the contract. There's a different standard under the UCC and in New Jersey, and I'll talk about that later. Impossibility, again, it requires a totally unanticipated event that could not have been foreseen or guarded against in the contract. If the parties could have addressed the event in the contract but didn't, you don't get the impossibility. And again, there's a basic assumption of non-occurrence. Courts will ask whether non-occurrence of the event was a basic assumption on which a contract was made. So in this case, courts will ask themselves, was a basic assumption of the contract that there wouldn't be a pandemic that would, cause whatever events it's causing. Okay, that's the key issue here. Okay, and here's a case from 1968 that talks about it's always assumed that the subject of the contract will not be destroyed. And here again, another important point. Under the impossibility of performance doctrine, it's very clear that changes in financial situations of the parties are generally not such a basic assumption that would trigger an impossibility of performance. It's an objective standard. The party seeking to invoke the impossibility could not have created it. And you have to show again that it either destroys the subject matter of the contract or the means of its performance. Two very important points. Some non-qualifying events. Impossibility doesn't occur when performance is simply more difficult or costly, can't be premised on financial hardship, can't be premised on just insolvency or an ability to obtain financing, doesn't occur when performance is simply unprofitable, doesn't occur when a party just ceases the obligation of an unprofitable business. Some qualifying events is an unforeseen change of law or government order. So we could have that in this case in certain circumstances, where a change of law makes the contract worthless to one of the parties, or if there's a court order. Also, some more examples where performance is subsequently prevented or prohibited by administrative order, where performance is precluded by a need to comply with the rules of a governmental authority, where subsequent action by the government made performance impossible by preventing the supplies necessary for performance. These are all issues that you can address in the contract. These are all events that may be occurring now that you consider qualifying events. New Jersey follows a lesser standard called impracticability of performance, and that's, again, if the existence of a specific thing that's necessary for the performance is either destroyed or deteriorated to the extent that it makes performance impracticable. It can be impracticable because of extreme and unreasonable difficulty, expense, injury, or loss to one of the parties. So it's a lesser standard than impossibility. Okay, examples of some impracticability under New Jersey law: severe shortage of raw materials or supplies due to war, unforeseen shutdown of major sources of supply, resulting in either a marked increase in cost or prevention of performance altogether. Impracticability because it involves a risk of injury to a person or property that's disproportionate to the ends to obtain by the performance. Connecticut also follows impracticability as a general rule if there's no force majeure clause. And it requires that, again, the event's a basic assumption on which the contract was made, and the impracticability was unforeseen and without the fault of the party seeking to be excused. Connecticut does say, though, that it's only available in unusual circumstances, and have pretty much, as a result of the Dills versus Enfield case, which you'll see cited there, has said that additional financial burdens generally do not justify you getting out of a contract on an impracticability basis, unless there is a real exceptional circumstance. UCC also follows an impracticability standard for the sale of goods. It's pretty similar to the impracticability standard in Connecticut and New Jersey. You have to show that the performance was impracticable in light of the occurrence of the event. I provided you here some examples of impracticability for contracts of the sales of goods. I'm going to move this along so Andrew has some time to speak. Here's some more examples. There's also a doctrine called frustration of purpose. It's very similar to impossibility. It's another argument you can make. It basically occurs when both parties can perform, but as a result of unforeseeable events, performance by one party would no longer give the other party what it expected under the contract. It has to be a totally cataclysmic, unforeseeable event that renders the contract valueless to one party. So something that's occurred, and now the contract is completely valueless, right? Your house was destroyed. Now your contract to buy, a specialty carpet for your house. That might be a frustration of purpose. That's the type of situation. Okay. Here's more points about frustration of purpose. And now I'm going to turn it over to Andrew, who's going to talk about the concepts of future contracts.
Thanks, Roy. Okay, so where we are right now is we've kind of explained to you what the law is, and we can help you navigate for getting out depending on what state you are. Amazingly enough, we're finding people are sending us contracts, I'm going to talk about that in a bit, which don't have any force majeure clause in it. They're silent on it. Actually, a lot of the financing agreements are really silent on it, okay? So what do we kind of do as we go forward? So while maybe there's teams of people dealing with getting out, then we have going forward. So first of all, most everyone on the phone call probably has some form contracts that they've been using, whether it's your supply chain contracts or your forms. They're going to have to be looked at, and I would suggest revised. That's a big issue, and so there's going to be some training going on with the people who either receive the contracts. So I know not everybody sends it to us. You should, but there may be people who just get contracts, and they're going to have to be educated. And by the way, everyone's going to be getting a link, maybe at the end of the day, if not by then tomorrow, which will have this recording. You might want to share that to sensitize those people. But one of the things that Roy and I have begun to discuss is, will pandemics be considered to be no longer unforeseeable, especially with those contracts which are not going, or they're going to be silent or immature or don't speak to it. I think for the next couple of years, maybe a court will think that a pandemic is something you should have thought about, and the parties didn't actually deal with it. They'll take that into account. I'm not so sure how long. Hopefully these memories that we're dealing with start to fade. But you need to consider whether you're including a force majeure, excluding them, or negotiate them. And again, if your contracts don't have them, some people are saying, oh, well, let's just be silent on it. If you do that, you are running the risk that the court is just going to assume that you took the risk. Okay, that's not where you want to be. And as everyone is pandemic crazy right now, you're going to really want to address that in specific. All right, let's go to the next slide. Now, I think especially, I know we have some large systems on the phone, maybe more complicated. You're going to have to really look at the language to make sure that, well, what I mean is you have to be thoughtful. You can't have a cookie approach. So maybe a key supply line will have one provision, and there'll be another provision as we move forward. Okay, I want to look at a basic contract right now. So I'm going to go to the next slide. And in the crisis of having the entire system crash half an hour before, we had improved on some of these provisions. So I'm gonna show this to you. I wouldn't say that this is necessarily the only one you can have, but for the non-lawyers on the phone, and by the way, if you want to ask questions, you should go ahead and ask them, and we'll try to answer them time permitting. But somebody asked the question, what does a force majeure provision really look like? So bless you that if you haven't had to look at them. But this is a typical one, but I want to point out some things now that maybe you're a little bit more educated in these provisions. So first of all, if you take a look at it, you'll see it says neither party shall be liable for X, Y, and Z, but we wrote limited to. As Roy had mentioned, we do not like the clause including but not limited to. So it's limited to, okay? Also, if you see where it says strikes, and it says not contractors, actually one of the revisions which didn't make their way in, that not contractors should be at the end. So it should be strikes, lockouts, or other labor disturbances, not the contractors. Meaning, if you're a key vendor to my hospital or my ASC or whatever it is, and you didn't pay the 3% raise that the union wanted, and they went on strike, well, that's not unforeseeable. That's on you. So we don't want you to get a way to walk out from that. So I would make that change. And then if you go to the second bullet point, you'll see it is expressly understood by the parties that this clause shall apply in the event that one of the above cases is beyond your control and renders the affected party's performance impractical. You'll see we put impossible. Again, depending on what you want. If you want to make it more difficult because you're receiving services, then make it impossible and cross out the word impractical, okay? The next one, the affected party shall provide the other party with prompt written notice. Okay, that's good because you want to be told. But we would suggest that you add there, or if it's likely to occur, okay? Because, I mean, let's take this pandemic. It came on so fast, so maybe this is really not a great example. But there are problems that may slowly be coming on, and they may not be a pandemic. They may be a shortage in copper, and the person probably needed copper. Well, did it start 3 months ago? Because and it's really important to add into this provision, or is likely to occur, because then you'll give us a chance as the receiver of those services to try to cover. And then the last one, again, suggest another change. However, in any event, if it goes on for more than 30 days, that's it. I don't want to get into, well, it's really not a force majeure, but it's been going on for 60 days. No, I would also change in there that if it's 30 consecutive days or 30 in any 60-day period, then you stop where the person can make one shipment, then stops, and then starts again. Okay, but now we want to show you something we think is pretty neat on the next slide. So, again, assuming that many of you are healthcare providers, as Roy was saying in his lead up on the great research he did, you'll see that that the courts are looking at these provisions to see, did you just consider them boilerplate, or did you really think about them? Did the parties get together and really start to negotiate it? So they're looking for some context. So we would suggest, in your basic healthcare contract, sticking something like this in, again, where you're receiving. Notwithstanding anything to the contrary, it is expressly understood that the provider is a healthcare provider, and as such has obligation and responsibility to provide necessary healthcare. And we just picked some, war, insurrections, or when performance under this agreement will be impracticable due to acts of God or other events. So here we're being broad, okay? So that the parties now, by signing this contract, are showing they recognize who is getting it. And it also, the next sense is it recognizes that we're relying on the contractor, okay? And then what we said in the next bullet point is that the contractor understands that performance under this agreement is not going to be excused, okay? Now, depending on who you are, if you're a very strong buyer, they may take this. If it's in your form contract, they may sign it and not even know. So you could try to do that, recognizing that many sellers may fight back. That's where hopefully we're all a little bit more educated and we'll have to make some choices. But there are some new fangled approaches that are coming out. I wanted to share one of them to you, which is on the next slide. And that is where this particular provision comes from a very large provider. It's a hospital system where it was a large contract, millions of dollars, sophisticated seller, and of course the buyer had very sophisticated counsel. So what we did is we tried to split the baby. Amazingly, this provision was negotiated before COVID-19. It makes us look like we knew this was coming, but we did not. So what we did in the first paragraph is, look, there are situations, the ones that are listed there, weather facilities, that may happen, okay? And you, vendor, you're going to have to provide that, but you're going to provide it at no additional cost, okay? And so we limited it to those, okay? So if there is, for example, tremendous snow, you better get us that supply. But the provision went on, which you'll see on the next slide, when we move to it, like now, there we go, that in these more specific one, and pandemic is the first one was there, that you have to still provide it, but you could charge more. Now, for those of you who are listening and saying, yeah, what, like an unlimited amount? No, we said that during it, you have the right to charge us for more, but the parties have to agree to it. We thought that this was an interesting approach because it broke it down by what's likely, which is, although we're in the middle of a pandemic, I don't think that's likely. Bad weather, sure, that's likely. So on the bad weather kind of stuff, you have to continue to perform. On these, you have a potential to charge us more, but it has to be agreed to. Okay, so there are other approaches. The time and the scope doesn't permit us to do all of them, but I wanted you to see a different kind of approach. Okay, the last slide, by the way, put those questions in, is something that representation and warranties. We've really been talking about supplies, but in asset and stock purchase agreements, they often do not include, amazingly enough, we've been looking at them, a broad force majeure clause. And it's almost non-existent, as I said before, in financing documents. So buyers and lenders are really going to have to look at these contracts kind of in a different way. There's usually specific performance clauses. There's also things in there called material adverse effect or material adverse condition. Those are called MAC clauses in the biz. They may not be in every agreement, but we think that those MAC clauses are going to really be relied on or scrutinized in the same way that we're talking about force majeure events. So it's unclear if the current crisis is going to trip up those events. those clauses, but we wanted you to at least be sensitized to it. Also, in those clauses, there's often a catch-all: any event, circumstance, change, or effect that is materially adverse to the business. That is kind of what I would call a mini force majeure. So if you want to exit those contracts or evaluate them, if you're mid, performance, you should really look at that. Moving forward, I can tell you that our team will be drafting and looking at these things very differently. Okay, so what's the next steps that we should do after all of this information? So one is purchasing managers, who are right now probably some of the most stressed people after nurses and doctors and healthcare lawyers, but they're going to have to start doing an inventory of their existing contracts. What do they say? How bad is the problem? What do they need to do, especially as contracts come up for renewal? And part of that inventory is really having a triage of what's important and what's not important, or not as important. Contact the vendors, as we said at the outset, reach out to them. People are kinder these days in business than you would have thought. Again, lay the groundwork for exiting, cancel those things. If you have to reschedule them and it turns out that this nightmare is over, so you got to, I think, be conservative. And revising the contracts needs to literally start now. And of course, our team is available to help. So with the 2 minutes left, we're going to go to the questions that people may have put in. And the first one I'll ask to Roy. Roy, this must be a provider. And by the way, if you want to add the questions, you can just pop them in there into the screen, and we will try to get back to you. Roy, one of the questions was, what do you do if you have a critical vendor and you want to hold them to the fire, so you want to go to court, but what about if you're in a jurisdiction where the court is closed?
Yeah, so that's going to be a problem. That's actually a question, Andrew, and that's going to be a problem over the next couple of days, next couple of weeks, I should say. For example, in New York, the courts are closed except for emergency applications. If you have a real critical vendor, particularly if it's a critical vendor with regard to healthcare or COVID-19 concerns, we can certainly contend with the court. There is parts open in every county that it's a critical issue, and ask for an emergency TRO to be heard. So if you do have that circumstance, you should let us know, and we can probably get it on to be heard pretty quickly. As I said, the courts are not totally closed on the state side. In New York, they're just partially closed, and we can get it in. All right.
Okay, one last question, because I see we're at the magic witching hour. Somebody says, does insurance cover any of these disruptions? So the answer is, we're looking at that. Business interruption insurance, the companies are saying it's not covered. They're finding their way to wiggle out, and of course, wanting to sell people endorsements. I think that battle is still going to be fought. But most people are looking at their insurances. We have a webinar that we're going to probably put on about that. I would not rely right now on insurance. Always file the claims to the extent you can. But I don't think that's going to get you out. Okay, so keep your questions coming. Tell us other topics that you want, and most of all, stay healthy and stay sane. And if you want to reach Roy or I, our contact numbers are on the slides, which you will be getting by the end of the day. Thank you, everyone, and God bless.
Bye-bye.